I might just start out with the issue to do with the payment of regulatory fines. So my understanding is that the former government effectively amended sections 56 and 57 of the SIS Act to prevent trustees and directors from using trust assets to pay a criminal, civil or administrative penalty incurred in relation to a contravention of Commonwealth law. Are you aware of that law reform?
Perhaps, Senator, I can take that one. Yes, we are, Senator. So we understand that took effect from January 2022, I believe.
It was in the Financial Sector Reform Hayne Royal Commission Response Bill 2020. So the intention of that law reform, I was in Parliament at the time, so I understand what the intention was to ensure that the members of the funds would not pay regulatory fines. That was the intention, wasn't
it? Yes, that's right, Senator.
Right.
So that trustees would cease to have the right of indemnity from the assets of the trust to pay any Commonwealth penalties. That's right.
Yeah. So let's play a hypothetical here. There's a super fund that fails to meet its obligations to members to pay death benefits, for example, when they are due. ASIC takes them to court and secures a large financial penalty. In that case, the average person would expect that the people that own and control the fund would pay the fine, not the members of the fund. That would be a reasonable person's assessment, wouldn't it?
Well, it's a bit, apologies, Senator, it's hard to comment on what the reasonable person might think. I suppose we can best comment on
Well, that's what the law says. That's what the law says. So it says here in the EM to the bill, it says here, Section 56 and 57 of the SIS Act now prevent trustees and directors from using trust assets to pay a criminal, civil or administrative penalty incurred in relation to a contravention of the Commonwealth law. So it's very clear. So the average person would think, well, that means that the super fund assets will not be used to pay fines incurred by the trustee. Does it not?
Well, I mean, Senator, you've correctly read out what the EM says, and I think we're all very, very clear, and there's no disagreement as to the intention behind that legislative change. Okay. That's correct.
That's good. I'm pleased to hear that. So then let's play forward. What happened after that? Was there a case that a number of super funds sought to change their trust deeds?
Yes, that's correct, Senator. So I think I beg your pardon?
What did they seek to do?
So what they sought to do, Senator, was a number of them applied to various state Supreme Courts seeking judicial advice on the trustees' ability to seek to amend the trust deed to enable them to charge a fee, which the trustee would charge to the fund, and it would enable the trustee to build up a trustee capital reserve, in effect becoming legally the trustee's own money once it had charged the fee.
Yeah, so they charge the fees from the members.
That's correct.
So they're not charging the shareholders of the funds, are they? They're charging the actual punters, the people, the members.
Yes, Senator, that's correct.
Okay, so the members' money goes into an account, and that then can be used to pay fines in the future.
Yes, that's correct.
Okay. So what was APRA's position, if any, when the funds were going to the state Supreme Courts to change their trust deed?
So, Senator, APRA played quite an active role in almost all of those trustee judicial advice applications. So we engaged with all of the trustees. We reviewed the documents they were submitting to court. We also participated in most of those court hearings or advice applications to in the form of being an amicus, so a friend of the court, where we outlined our view of what various trustee duties require, such as the best financial interest duty, in order to inform the court and assist the court to provide its views on the matter.
Well, I mean, I just think that's extraordinary. So APRA supported the fund's attempt to build up a reservoir of money from the members, did it?
No, that's not quite right, Senator. As I say, we didn't participate where we were proactively in support. We participated to help inform the court as to the legislative framework.
Ms McCann, that totally undermines the object of these reforms. It undermines the Parliament's intention.
Well, Senator, it was a matter that was carefully considered by a number of Supreme Courts around Australia, and I think this is all public in terms of the information that would be available from the court lists, which was to the effect that the courts found that it was not inconsistent with the best financial interest of members to enable trustees to build up these fees in order to avoid a situation where a trustee became insolvent and unable to perform its duties.
Yeah, but now you've got the situation where the funds are making huge transfers of money to unions and employer groups, their shareholders, each and every year, massive transfers, in some cases millions of dollars to individual unions, some of which you're investigating at the moment. And yet these unions receive all this money, as do the employer groups, but they're not on the hook for supporting the fund when things go wrong. So they take money out of the fund, but they want the members to pay the regulatory fine. So the trustees make errors and the members pay. What steps have you taken to get some capital in accordance with the Act now from the shareholder companies that own these funds, that receive dividends from them?
Well, none, Senator. I don't know that I would say that it's our role.
Well, I think you've misread your role here if you have supported this position, which has undermined the operation of the Act, because effectively what you're now going to see happen is, in the case of CBUS or other funds, if they are on the hook for significant fines, it's the members that are going to pay. And meanwhile, they're paying the CFMEU huge transfers. So it's a completely broken system, and it was designed to be one which protected the member interests with these changes in 2020.
Senator, I might just say that it's not APRA hasn't either supported or not the position. What APRA's role is to supervise to the law as it's currently written.
Yeah, well, you've got a bunch of organisations that are receiving a lot of money from this superannuation scheme that are not providing any capital at all for the occurrence when there are regulatory fines. I think it's quite extraordinary. Anyway, but basically your evidence is that the trustee amendments were made. They were made by the Supreme Courts. APRA didn't take a position.
That's correct, Senator. So, and just to be clear, the amendments were made by the trustees themselves, but with the benefit of judicial advice.
Yeah, of course, the trustees. Yeah,
yes,
they've acted in their own interest, and they've obviated the law. They've found a way around the law, which is quite extraordinary.